We have talked a lot in recent months about an escalating constitutional crisis, a confrontation between an overreaching executive branch with Trump claiming the powers of a monarch and the courts, which have, imperfectly been standing up to him. Lower court judges in particular have been brave and courageous in applying the law neutrally to stop Trump's unconstitutional overreach. And what that has provoked has been a huge surge of attacks on judges, threats of impeachment, rulings from lower court judges that the Trump administration has defied their orders. We had one of those just this week as a district judge in Massachusetts held that the administration had violated his order regarding the removal of migrants to war-torn Sudan. So we've got this big conflict between these two branches, Congress effectively standing to the side. One dimension that has not really been explored enough, in our view, is what happens when this conflict comes to a real head. It's been something we at Court Accountability have been working hard on, particularly with our friends in Congress, who we're excited to announce have introduced new legislation to address these challenges. What are these challenges? We really see a twin set of challenges, and both relate to the U.S. Marshals Service. This is the law enforcement agency that is charged with protecting judges and carrying out judicial orders, among some other judicially related functions. And structurally, the U.S. Marshals Service is set up within the executive branch. Obviously, already you can see where we start to have challenges here. Because if indeed a judge like the one in the District of Massachusetts, who explicitly called out the possibility of criminal contempt in this case, if he issues a contempt order, that order would need to be enforced by the marshals, who are under the direction of Pam Bondi, Trump's corrupt lackey of an attorney general. So real serious problems on the contempt enforcement front. And then perhaps more acutely, problems with respect to judicial security. It's the marshals that are charged with protecting judges from violent threats. And we've seen from recent reporting from Wired and others that there's been a sharp increase in threats to judges. On social media, we've seen a 320% increase, 327% increase in threats to judges since just last year. It's almost all of them are connected to adverse rulings to the Trump administration from lower court judges of both parties. It has extended beyond the digital realm. Judges like Michelle Childs on the DC Circuit, an appeals court, have received ominous anonymous deliveries of pizza boxes to their houses, a not very well-veiled threat that the sender of those pizzas knows where the judge lives. All of this has created a chilling, intimidating, very dangerous environment. And if it is the executive branch, Trump, MAGA, Elon Musk, their allies in Congress who are leveling these threats, who are stoking this type of stochastic terrorism, how can we really trust the executive branch to allow the marshals to protect the judges? And so what can we do about this? We're so excited that out of the Senate and out of the House today, Thursday, the 22nd of May, we've seen the introduction of a new piece of legislation, which would actually restore a historic status quo, simply moving the Marshals Service from the executive branch to the judicial branch. We at Court Accountability, not normally huge fans of giving the courts more power. We think a lot of the reasons we are in this ugly situation today are because a right-wing Supreme Court majority has sort of broken the tools of democracy to allow authoritarians and oligarchs and theocrats to dominate. But at this moment, given the escalation of these threats and the concerns with incredibly unprecedented executive overreach, we concluded that there's no alternative but to give the judiciary control, with congressional supervision, of course, to control the marshals who protect them and who can be trusted in that structure to carry out their orders. So we're going to do a lot to rally support, bring public attention to this issue. Interestingly, this used to be an issue of bipartisan commonality, not necessarily the question of where the Marshals Service should live, but the question of prioritizing protection of judges in the face of threats to them. And Republicans have been leaders on this in the not so distant past. It was just a few years ago that a district judge in New Jersey, Judge Esther Salas, experienced a horrific tragedy as an angry party that she had ruled against in court attacked her family, murdered her son, Daniel Androl. I was a staffer in the Senate. We worked across party lines to advance legislation to protect judges' personally identifying information to guard them against those threats. Chief Justice Roberts, I would argue in some amount of bad faith, and Senate Republicans also in bad faith, really lambasted Chuck Schumer for decrying a decision by the Supreme Court where, perhaps speaking a little bit out of school, he said that the justices would pay a price. He was actually, paraphrasing something that Justice Kavanaugh had said during his own confirmation hearing about reaping the whirlwind. Those were the words that Schumer used at the front of the Supreme Court steps. But ever since he did so, Republicans have hung that statement around his neck and tried to intimidate him and chill him from holding the Supreme Court accountable by equating that criticism to increasing the threat of violence against these judges. So, this has been an issue that Republicans have said they cared about, have done things to, make steps to improve in the past. There are no Republican co-sponsors on these bills. My understanding from working with allies in the House was that there were efforts to bring Republicans on board. I know that Senate Democrats like Booker and Leader Schumer himself, who is a co-sponsor of this legislation, have tried to get Republicans on board with it, but they've not found any interest. And that is, it's self-evident as to why, even if they agree with this in principle, even if they agree that behind closed doors, that the Trump administration is overstepping and that judges do need to be protected, politically, they can't get crosswise with MAGA, and so they're not going to be there for it. But this isn't just a messaging bill. This is a real priority. This is not just a matter of politics. Something bad is going to happen. And we're living in an environment where political violence is more and more common, where threats of violence are proliferating. And if Congress doesn't take affirmative steps to protect the judiciary for simply doing its job, then something really dangerous and bad is going to happen. And so we collectively need to really ramp up the pressure to see this legislation be advanced. Next week, with our allies, many of our movement partners that you hear from us on this show with, our friends and allies in the pro-democracy advocacy ecosystem, will be sending a letter to the House and Senate Judiciary Committees next week, urging them to take up this bill, the Marshals Act, and to advance it, to protect the judicial system, to protect judicial independence. So I wanted to have this hot take here with you here today on Midas Touch Legal AF to encourage you, if you're looking for a way to get involved, this is a great opportunity. Reach out to your senators, particularly if they sit on the House or the Senate Judiciary Committees. Reach out to Chuck Grassley, the chairman of the Republican chairman of the Senate Judiciary Committee, and Jim Jordan, the Republican chairman of the House Judiciary Committee, and let them know this should be a priority and completely nonpartisan, completely consistent with past positions of the Republican Party when it comes to judicial independence. Let's make this happen. Let's rally a charge around this and keep it going, because not only is this a moral imperative at a moment of deep danger to our constitutional republic, it's a real opportunity to flex our muscles as an advocacy community, as engaged citizens, and for Congress to flex its muscles to confront the dangerous authoritarian overreach of Trump and the MAGA administration. That's it for me on this hot take. Thank you, as always, for joining us on Court Accountability with Legal AF. Please don't forget to hit that like and subscribe button. Check out our work for more of our analysis and advocacy and research at courtaccountability.org and at Tilted Scales on Substack. We'll throw all the links in the show notes, including to the legislation and to lists of your members, so that you can reach out and make sure that your voice is heard on this important issue. Until next time, stay mad, stay motivated, stay mighty. Signing off.
I'm Michael Popak, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF, and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popak Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popak Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states, and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popak Firm today at 1-877-POPAK-AF or by visiting my website at www.thepopakfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popak Firm, fighting for your justice every step of the way.